Police roll call. This is Stanley Cohen. I'm an attorney at law, a former Cincinnati, Ohio police officer, a former professor of law at Indiana University of Pennsylvania in Indiana, PA. The goal of this channel will be to state appellate court decisions that state the legal authority of police officers to enforce the law on the street and to enable police officers to defeat defense attorney motions to suppress evidence and their motions to dismiss charges. The opinion that I'm going to discuss today is Commonwealth versus Bathurst. In this case, two police officers were on patrol when they saw the defendant sitting in his car parked on the side of the road. He has rear taillights on. They decided to go to check him out. So they pulled their cruiser up behind his car. They parked about 10 to 15 feet away, leaving him a space in front to be able to drive away if he wanted to. They did this, of course, for the reason to create a mere encounter, which does not require reasonable suspicion of criminal activity to engage in. We have a roll call question at this time for all of you. Would the officers be required to have reasonable suspicion that the driver is involved in criminal activity in order to ask him his name and the reasons why he's sitting in that location? Think about that a while. The answer will appear when we discuss the opinion shortly. The officers noticed that the car was running, key was in the ignition, and that there was a case of beer on the back seat with empty beer bottles around. And they smelled the odor of alcohol on his breath, and he looked to them as if he was under the influence of alcohol. So they asked him to get out of the car, and when he did, they subjected him to a sobriety test, which he failed. They then arrested him, and in court, he made a motion to suppress the evidence, and the trial court denied the motion, and he was convicted. He appealed. When the case got to the appeal court, the court affirmed the lower court's denial of the motion to suppress, and they did so on the basis of the following reasoning. They applied the Fourth Amendment, which states, all persons shall be secure in their persons, houses, personal possessions, against unreasonable searches and seizures. So the court focused on the word seizure. They had to determine whether the defendant was seized or not. And of course, if he was seized, the court had to determine if there was sufficient reasonable suspicion of criminal activity in order for the seizure to be lawful. So the court chose to apply the reasonable person test to determine if the defendant was seized or not. And this test states as follows. When a police officer uses words or actions that would make a reasonable person feel free to walk away, the person has not been seized. On the other hand, if the words and the actions of the officers, when communicated to a reasonable person, would make a reasonable person feel not free to walk away, then the person is seized. And in order for that seizure to be lawful, the officer must possess sufficient information to constitute reasonable suspicion that the person was involved in a criminal activity. And in this case, the court reasoned that when the officers asked the defendant, Bathurst, to get out of the car, that's when there was a seizure, because a reasonable person would not feel free to walk away. So he was seized at that time. But by that time, the officer had reasonable suspicion that he was involved in criminal activity. They saw a case of beer on the back seat with empty beer bottles. He smelled of alcohol on his breath. He stuttered. And so they had reasonable suspicion at the time that they ordered him out of the car, and therefore the seizure was lawful. And that is the Bathurst case. If you would like to watch other appellate court decisions like this one, please subscribe below.